On 31st of March of 2010, the pre-trial Chamber 2 of the International Criminal Court granted the prosecutor's request to commence an investigation of crimes against humanity allegedly committed in the Republic of Kenya. We talked to Gilbert Biti, Senior Legal Advisor to the Pre-Trial Division, about the decision and the next steps.
When the prosecutor decides to investigate proprio motu, which means that he didn't receive a referral by a state party or by the Security Council, he has to get first the approval of a pre-trial chamber before he can start the investigation, so before he can start collecting evidence. And this is what has been the task of pre-trial chamber 2 for the last 4 months. The decision process means that the chamber, so the 3 judges, are going to look at 2 different things. The first thing they look is the request of the prosecutor together with the supporting material, so the information that the prosecutor was able to collect before presenting his request. And he has limited power because he cannot investigate. So he has collected some information, which was actually publicly available information, which he has presented to the chamber. And it was still a lot of information. It was 1,500 pages. Then the chamber had also at its disposal the victims' representation. So victims came to the chamber in order to present also their representations, their views about the investigation to be authorized or not. And that was also very useful material for the chamber. A pre-trial chamber is always composed of 3 judges. They all come from different countries. In this particular case, pre-trial chamber 2 is composed of Judge Ekaterina Trendafilova as the presiding judge from Bulgaria. And then we have Judge Hans-Peter Kaul from Germany, and we have Judge Cuno Tarfusser from Italy. The judges disagreed on the fact that in Kenya, crimes against humanity were committed or not. One has to understand that the description, the definition, I would say, of crimes against humanity in the Rome Statute is particular to the Rome Statute. There are some requirements, especially the requirement that the crimes were committed pursuant or in furtherance of a policy of a state or an organization. This is a particular definition for the Rome Statute, and it means that the threshold to reach those crimes against humanity is quite high. And this is a limitation on the jurisdiction of the court. One also has to understand that there is not much jurisprudence of the ICC on this particular topic. The ICC is a new institution, and for example, there is absolutely no jurisprudence from the appeals chamber of the ICC on the notion of crimes against humanity. So the judges did not agree on the definition of crimes against humanity. One of the judges thought that actually what was committed in Kenya, and he didn't deny that crimes were committed, but he was of the view that the information provided did not show that those crimes were crimes against humanity provided as defined in the Rome Statute. The other 2 judges were of the opinion, first, that the threshold was very low as far as the information to be presented is concerned, and that actually there was sufficient information to reach the threshold of the Rome Statute. So there was disagreement on what are crimes against humanity in the Rome Statute. The prosecutor now can start its investigation. But at the beginning of its investigation, now, he has to send letters to all states which could normally exercise jurisdiction, and in particular to Kenya. And Kenya has the right, within 1 month, to request deferral of the investigation to the Kenyan authorities. Once again, fundamental principle of the Rome Statute, we are simply a complementary court. Logically, it is for national courts to have the priority for the investigation and the prosecution. But Kenya will have to demonstrate that actually they are investigating and prosecuting those people who are likely to be the object of cases before the court. And this is why we requested a list of potential perpetrators to the prosecutor, a list which is not binding for the prosecutor. This is the first step. If Kenya, within 1 month, does not come to the court and request deferral of the investigation, then the prosecutor can proceed with his investigation. And then I have to explain that the proceedings are going to be of a different nature. For the moment, what we were doing is to see if there were crimes within the jurisdiction of the court committed in Kenya. So the question was, what was committed in Kenya? Now the question is different. The question is going to be for the prosecutor to prove who did what. So now, after the Article 18, the notification, when the prosecutor will come with a request, either for a warrant of arrest or a summons to appear under Article 58, he will have to prove to the required standard who did what. He will have to investigate in order to present evidence not only on the commission of the crimes, but what is the role of some people in the commission of those crimes. And this is going to be the next debate where he will have to come back to the chamber, to the pretrial chamber, the same pretrial chamber, with evidence in relation not only to crimes, but to persons responsible for those crimes. I just want to say very clearly that the role of the victims does not stop at the proceedings under Article 15. Their role was very useful for the chamber. Now the authorization has been given. The role of the victims goes on for all the stage of the proceedings before the ICC. They have, under the statute, the right to participate. So I just want to stress that because this is important for them to know that they have a right under the Rome Statute to participate at all the different stages of the proceedings.
On Thursday, April 1st, 2010, ICC Prosecutor Luis Moreno-Ocampo held a press conference in the court premises and laid out the exact steps the office will take in investigation of crimes committed during the post-election violence in Kenya in 2008.
The judges decided there will be justice in Kenya. To contribute to the prevention of crimes during the next elections, we must proceed promptly. We will. There is a list of 20 suspects, but it is not binding. We envision at least 2 cases against 1 to 3 persons in each case. We will focus on those most responsible according to the evidence that will be impartially collected. We aim to finalize the bulk of the investigation during 2010. We will present our case before the judges. They will decide. This is a judicial process starting. Now, as that the opening of the investigation has been authorized, I will travel to Kenya. I will do it in May. I will meet with those who suffer the crimes, and I will visit some of the crime scenes. I will listen to the victims, respect their interests, and request justice for them in court. We have a duty to protect each of our witnesses, and we will. We will do it independently. It is also the responsibility of the Kenyan authorities to ensure that all those who speak in favor of justice are duly protected. We aim to finalize the bulk of the investigation during 2010. We will present our case before the judges. The judges will decide. Important. We'll analyze the best way to ensure the appearance of the suspect in court. There are different options. We can request an arrest warrant. We can request a sealed arrest warrant, or a summons to appear if the suspect express willingness to cooperate and accept to appear voluntarily before the judges. Then, again, the judges will decide. To finalize my previous comment and then let you make questions, let me be clear. This is a judicial process, but it's a judicial process that will be conducted with the Kenyan, for the Kenyans, including all the communities in Kenya. This court is the Kenyan court. We are an independent part of the Kenyan justice system, supported by 111 states. And will help Kenyan leaders, women, youth, tribal leaders, religious leaders, judicial leaders, political leaders. All have a role to play. My duty is to understand them, to respect them. I would like to analyze together how we can work to prevent future violence. The fifth anniversary of Kenyan independence is coming. It's an historic opportunity to show an example of how a country overcomes violence.
Kenya journalists had an opportunity to ask questions during the press conference through a video link from Nairobi.
I'm Judy Kaberia from Capital FM. My concern is about some of the suspects that you already have in your list. How will you deal with them if they start inciting people again or asking people to start violence so that, to boycott your investigations? How are you going to deal with them, because this has been common and it's already been said?
The court show respect for the victims, respect for the law, but also the prosecutor will show respect for the suspects. They are just suspects, they have rights. So I invite them to provide to me the information that they consider proper to show they are not involved in the crimes. We have no prejudice. So today, no one is guilty in Kenya, and we'll collect evidence, and we have a duty to investigate exonerating information. So I invite publicly any person who believes is suspect and like to explain to us why he's not involved, they can call us. We'll listen to them respectfully. They have rights, will be respected.